Hey guys, I can see looking online, everybody took the test. That's a good thing. As we venture down this path, teaching online is new for me. Hopefully, it's not too boring for you. I know neither one of us want to be doing this, but here we are. So I'm glad you took the test. We're going to move forward now into chapter 4. It's a lengthy chapter. A lot of chapter 4, when we talk about searches, a lot of it should be refreshing most of you from 1010 class. Again, I don't know who you had for 1010. I don't know if you've been allowed into the class without taking 1010. So a lot of this, I'm not going to be able to talk about the length of the Fourth Amendment. So this is going to be one of those chapters in the book. If you haven't, got the book yet, you have to get the book. There's going to be a lot of stuff involving the Fourth Amendment to the Constitution, and a lot of stuff that's inside of Chapter 4. I'm going to hit some highlights today that I think that are important as an investigator, but ultimately you're going to be responsible for a lot of stuff. So go through Chapter 4. If you're going to get into this career, it's something you really need to know. And I'll be honest, I was very bad at it. I was one of those on the team when I got into an investigative detail that I'd get picked on because I loved to chase the bad guy. I wanted to chase after the bad guy. I loved to arrest. I loved to interview and interrogate. And ultimately, it left a lot of other detectives that had to pick up the pieces, that evidence. Evidence, when we talk about evidence, is extremely important. We live in a society and a system where the evidence is important because people lie. I mean, that's the bottom line. I'm not going to brush over it. People lie, not just the bad guy. The bad guy certainly lies, and so we have to prove it with evidence. But cops and investigators can lie. So because people lie, we have this game we have with evidence that in the United States criminal justice system, if we don't play the game right, the courts will get rid of the evidence. We won't be allowed to use it. If we don't have the evidence, we can't prove to a jury who really doesn't know who's lying. Are the cops lying or is the suspect lying? They don't know who's lying, and we need to show them through this evidence that we're telling the truth. So it's a game we play. It's extremely important to collect evidence in a manner that we are legal, because if we don't do it, we're going to lose it. But on top of that, there's certain things that you have to understand as an investigator that are important when we talk about evidence. The first is it's got to be relevant. When we talk about, so in your notes, write this down. Evidence must be relevant, otherwise the courts will not allow it. The judge will kick it out. There must be a connection between this fact that we're trying to show in court, this piece of evidence, and what we're trying to prove. If it doesn't make any sense and it's not relevant, the court will throw it out. And yes, many attorneys play games because they try and give so much to a jury that it confuses them. Relevant means it has to be important enough, that when you're looking at this overall, does it make sense? Do we need to be looking at it? The evidence also has to be material. So when we're talking about material evidence, it's nothing more complicated than, is it important enough that the jury would change their mind after looking at it? When a judge looks at evidence that we're going to provide to them, the judge is going to say, is it material? Meaning, yeah, this is important. It could change what the jury is thinking about, what they're trying to decide. If the judge thinks it's not important, and no matter what we do with this evidence, it's not going to change the jury's mind, then it's not material, and therefore it can be excluded from the court. So it has to be relevant, it has to be material. And then third, and most contentious, is that the evidence must be lawfully obtained. You have to get this evidence legally, otherwise our system is designed to get rid of it. We exclude it. So in Chapter 4, go back and I want you to look at the exclusionary rule. It doesn't matter how much you hate this exclusionary rule. We have a system that says that when the cops and the detectives, the investigators, do something wrong, illegal, then that illegal activity is going to result in the evidence being excluded from court. It's a way of punishing police. It's there. It's a good thing. It makes us do the right thing. And therefore, if it's excluded, we can't present it to a jury. So it's extremely important to understand that evidence, we need it to show somebody did something, because obviously they're lying. If I could just put their hand on some kind of machine and force them to tell the truth, I would never need to have evidence. If I could get the cops to do the same thing, never lie about what they did, we wouldn't need to have evidence. We need evidence. So as we start to talk about chapter 4, understand that I could spend an entire year, and in fact, for those of you going on to law school, you'll spend an entire year talking about the Fourth Amendment and the things that you can and that you cannot do based on what's legal and what's not illegal. And ultimately, as an investigator, this results in a search warrant. Remember, you're trying to get a search warrant on somebody's house, their car, something, so that you can obtain evidence to prove something in court. You have to have certain things in order to do that. So let's talk about those things. First thing is, I want you to have an understanding of probable cause. Go back and read in chapter 4. You should know this from 1010 class. Probable cause is extremely important in this career path. If you haven't had to memorize it yet, memorize probable cause. It's the facts and circumstances that would warrant a prudent person in believing that a crime had been committed and that the accused committed it. This is extremely important. Understand that. Understand the Fourth Amendment. Because we're going to talk about things that you can do as an investigator so that you don't have to go and get a search warrant. And a lot of investigators overlook this. Yes, knowing what you need to do to get a search warrant is extremely important, which is probable cause. But there are a lot of things that you can do to expedite this investigative process. The first being consent. Don't forget about consent. That's one of the first things that detectives forget. Yeah, in most cases, if you don't have probable cause, you can't get a search warrant, you can't search their house. But why not just knock on the door and go, hey, I'm here because of this. I'm Detective Swanson from the Las Vegas Metropolitan Police Department. Can I look in your house? You will be shocked at how many people that say, sure, come on in. It's not your responsibility to be in their head and say, why would you possibly give me permission? If they give you permission, great. You've now just expedited the process. Do not forget about consent. Go into chapter 4 and read about it. Clearly, if you get consent, it's going to be documented. You're going to write down, they're going to sign away their right, because they don't have to let you look. But if they do, great. In 1010, you should have talked about all those different exigent circumstances, meaning there are emergencies. Certainly, there are times when you don't have to have a warrant. If somebody dials 911 because someone's having a heart attack, and as a law enforcement, you respond with FD, fire department, and you're inside this house without a warrant, and you see things in plain view, you don't have to have a warrant. That emergency exigent circumstance allowed you to come in. So go into chapter 4 and look at those. There's a numerous amount of things that develop around exigent when we talk about those emergencies. The thing that I want to impress upon you on all of this conversation is that the Supreme Court looks at it as when you are searching, whether it's a search warrant or you're there because of consent or an exigent circumstance, you must search. Your scope is narrow in scope. That's the term the Supreme Court came up with, narrow. If you're there and you're there doing CPR on somebody in the living room because it was an exigent circumstance, you're not allowed to look in bedrooms. You're not allowed to look in bathrooms. It must be narrow in scope, meaning you're in the living room. Yeah, you can look in the living room. That's about where you're at. If you get a search warrant based on probable cause, in your search warrant, the judge will not sign that warrant if you're not narrow in what you're looking for. The Supreme Court's going to allow you to violate their Fourth Amendment if you have probable cause, but they want you to be narrow in, tell us what you want us to look for. So again, be very narrow in what you're looking for. A lot of questions that I get asked in my class are searches incident to arrest. This is, again, an exception to the Fourth Amendment. The Supreme Court has said that when you arrest somebody, We don't want them to have things upon them that they can take into our jail that can hurt other people, like guns, narcotics. So when you arrest somebody, if you have a lawful arrest, once you place them under arrest and put them in handcuffs, you're allowed to search them incident to arrest, meaning you can search them and check through their body. I mean, when I say body, I mean body. Not only their pockets, but when you get them to the jail staff will do body cavity searches. We're allowed to do this without a warrant because of the safety of that facility. So yes, you can do body cavity searches. Again, we could spend an entire semester on there are parameters and there are policies in place to protect the suspect when we do those kinds of things. Plain view exception. Again, go into chapter 4, look at plain view. There are things you can do, there are things you cannot do as an investigator. Clearly, if I'm walking down the sidewalk, I can look from the street in through a window that everybody else can look in. Am I allowed to hop over your back fence and look? No. There are certain things that people have this expectation of privacy. So be reasonable about this when we talk about exceptions. My golden rule when I teach new officers and new detectives, here's what I want you to understand. Don't get caught up in trying to beat the system and have an exception if you can get a warrant. If you have time that you're not going to lose evidence, get a warrant. If you're sitting on a scene and you don't know, do I have an exception? Get a warrant. So what I'm trying to tell you is, if you don't know what to do, get a warrant, because a warrant will protect you. Remember, you're going to lose any evidence that you obtained illegally if you did something wrong. Getting a warrant will protect you, unless you lie about it. Again, that's why we're in this whole boat. In the end, you're going to be writing up your probable cause, saying to a magistrate, this is why I want to go and look into their house. Don't lie about this stuff. Explain your probable cause. If the judge or magistrates agree, they're going to allow you to do that. Look at chapter 4. Go over those. Certainly, I'm going to ask you questions on the test about the Fourth Amendment, but it's way too much. I'd have a video here of 5 lectures if I tried to do that, especially when we talk about vehicle stops. I always get asked, in face-to-face classes, can a cop look at my car and this and that? Read through this. But at this point, like I do in all my lectures, I'm going to give you your assignment. What I want you to do for tomorrow, I think I'm going to probably assign it and have it due Thursday. But I want you to look online, and I want you to look into the Supreme Court case of Mapp versus Ohio. M-A-P-P. Mary Adam Paul. Mapp versus Ohio. Extremely important case in 1961. I want you to pull it up. I want you to look at what happened in Mapp versus Ohio. This is clearly a landmark case that stated what cops can do and what they cannot do based on what happened in Mapp versus Ohio. Your assignment is, I want you to write me in a page or two the details of what did the police officers and investigators do in this case, and why did the Supreme Court decide based on what did they do? What wrong things did the cops do that created the decision that the Supreme Court made, and ultimately why we're doing the things that we are doing today? So your assignment is research Mapp versus Ohio. I want you to understand that court case. So as we move through the Fourth Amendment, you're going to be seeing about open fields. Ultimately, this rolls into stop and frisk. Again, landmark case, Terry versus Ohio. Know this case. I want you to go into chapter 4 and read about it. This whole idea, this new idea the Supreme Court brought up about reasonable suspicion, about people acting, the way that they do that are strange, and cops having that right to stop them on the street. I can tell you, folks, that based on law enforcement doing things wrong over the past couple of years, we're probably at risk of losing this authority to stop people just based on that reasonable suspicion. So I want you to look at this and go over stop and frisk and have an understanding of that. It's going to come up in the next presidential election. Whoever the candidates are, they're going to be talking about this. Should the police department and law enforcement have that right to stop people without probable cause? Today, yes, based on this particular concept. So go over that, have an understanding. Again, this is stuff that should be refreshed from 1010. I'm not going to beat it to death, but you should know it. What I do want you to understand is that as an investigator or cop, there are really 3 levels of encounters that you as a cop should have with the public. The first is a consensual stop. Detectives and cops can stop and talk to anybody under a consensual stop, meaning go and talk to people. If you're trying to find evidence, go talk to them. People don't have to talk back to you. That's the key here. In a consensual stop, I can come up to your door, knock on your door, and I can ask you questions. If you say, get the hell out of here, I want nothing to do with you, you have to leave. Under a consensual stop, you have nothing that can force them to do anything. You're just talking, but they don't have to answer. Second level, and this is where we talked about that reasonable suspicion. You have the right to stop people that are acting in a manner that you think is violating some type of crime. Not an excuse for racial profiling. Again, don't get caught up into that. But if you think they're involved in some type of crime, level 2, reasonable suspicion, yes, you can detain them and you can talk to them and ask them questions. Some of those questions they have to respond to at this level. The third level is when you have probable cause and you arrest them. So the third level when cops talk to people is, I have probable cause and I'm going to make an arrest. Understand those 3 levels. A lot of new officers and detectives get confused. They try and force people to stay there and talk. You can't have someone and tell that person they have to stay there unless you have reasonable suspicion. They can leave whenever they want. So again, I'm not going to beat this up. I want you to understand those 3 levels. Let's talk about a search warrant, because ultimately, as a detective, you're going to be writing up a lot of search warrants. We're trying to obtain evidence from people that we think committed a crime. In order to get a search warrant, you must have probable cause. You write this in an essay format, you deliver it to a magistrate. They're going to read your probable cause. You're going to be saying, these are the facts, these are the circumstances, I want to go into this house and I want to look narrowly for this evidence. If they agree, they sign it. That gives you the authority to violate the Fourth Amendment and go in and look for that particular type of evidence. Here's the things that I want you to understand from this class. When we talk about service of that warrant, service of a warrant is when you're executing it. You've presented it, the magistrate has signed it, and now you're there and you've got it in your hand. What do? Supreme Court has laid out certain rules that you have to follow. The first is, from the moment that you get it signed, it is fresh, this probable cause. You have 7 days. The Supreme Court says, if the judge signs this probable cause statement giving you that right, you have 7 days to execute it. After 8, 9, 10 days, it's not going to be fresh. You can't serve that. You no longer have the right. The next one is, the Supreme Court says we want these executed in the daytime, unless you get exceptions. Yes, you can get exceptions. The next one is knock and announce. Supreme Court says we want you to knock and announce that you're law enforcement. This is becoming extremely important today, because how many times in the news do we see the cops barge in and shoot somebody because they had the wrong house? Knock and announce is something that we can spend an entire semester on. Right now, the Supreme Court says you must knock before you bust the door down. Do law enforcement do it? Well, most don't. They do it simultaneously. It's like knock, knock, boom, come through. So remember, knock and announce is there. So at that point, when we do go in, we search for evidence, we're going to leave that person with evidence behind, showing them this is what we took from your residence. Understand how we execute that. But before I leave, I want you to understand, you're going to be responsible for the Fourth Amendment, fruits of the poisonous trees doctrine, the exclusionary rule doctrine, Mack versus Ohio. You're going to be responsible for Terry versus Ohio. Go in and read this, understand this, know it like the back of your hand. It's extremely important that you understand Weeks versus the United States. Again, Weeks versus the United States. Because a lot of this has to do with what cops can do and what they cannot do. Before I leave, I want you to understand negative evidence. Negative evidence is play this like it's chess. Even though you don't think this evidence is important, that you don't need it for your case, do everything you can to gather it, impound it because it could be important. Negative evidence is trying to play it as if I get asked this question in court, can I answer that piece of evidence? Even though I didn't think it was important, the defense might think it's important. So look at everything. Look at chapter 4. Next time we're going to talk about chapter 5. I'm going to show you videos about fingerprinting, gathering evidence from ballistics, and gathering evidence from blood spatter. So read chapter 4. Next time we'll get to chapter 5. See you next time.